I had a feeling something was about to drop. You could almost sense that quiet tension building behind the scenes of the Reynolds and Lively household. And it wasn't hard to guess why. Things that were probably anything but calm, because after that unsealed audio between Clara Yubb and Steve Sarowitz became public, the internet started buzzing. And behind closed doors, Ryan and Blake must have been raging, because what we heard in that call wasn't at all how it had been portrayed. Originally, that recording was meant to support Blake. It was supposed to make her look like the victim of a toxic work environment, a brave woman standing up to corporate manipulation and abuse. Her team believed it would prove that she'd been wronged by Wayfair and Belden, that she'd been silenced and disrespected in the process of making her film. But once people actually heard it, the reaction was the opposite. The tape didn't make her look like the victim, it undercut her story. It changed the narrative completely. What it revealed wasn't harassment or discrimination. It was ego, power, and creative control. It showed a struggle over who got to shape the public perception of the movie, who got to control its message, and how Blake wanted the story told not just on screen, but in the press. The recording exposed something deeper, the kind of internal clash that happens when image meets reality. According to insiders, Blake and director Belden had been drifting apart creatively for months. The tension became visible on the press tour, the awkward body language, the distance between them during interviews, the inconsistent talking points. And Sarowitz's references to OBS in the call hinted that there were conversations happening behind the scenes, conversations about damage control and whether this mess could spill into court. At one point, they even debated whether to take it legal, but ultimately decided against it. That's when things started to spiral. Around the same time, Blake and Ryan reportedly pushed for a letter that would take responsibility for the backlash and reframe her as the misunderstood professional trying to protect her vision. And that's also the same period when Jones Works allegedly handed over data from Genable's phone data that wasn't even theirs to share. Suddenly, everything connected. So now, fast forward to present. The negative headlines hit. Blake's credibility is under attack, and the so-called evidence she believed would defend her has done the opposite. How does she respond? She strikes back legally. Her team files a motion for sanctions, accusing Wayfair, Wallace, and several others of spoliation in simple terms, destroying or hiding evidence. In her new filing, Blake claims that Wayfair, Belden, Jamie Heath, Jed Wallace, and PR firm Tag all use Signal voice memos and auto-deleting messages to coordinate a secret digital campaign against her in late 2024. According to her, they didn't just gossip, they plotted. She alleges they shared mocking voice notes, planned ways to label her as difficult, and crafted talking points to bury her in the press. All of it, she says, was retaliation. It's a wild claim, one that sounds like something out of a Hollywood thriller. But here's the catch. She has no proof. None. She has no screenshots, no backups, no server logs. Her entire case rests on circumstantial evidence, the belief that because they used Signal and some messages disappeared, those deleted chats must have contained incriminating information. In her argument, she insists that the group failed to disable auto-delete after litigation became foreseeable, meaning if a lawsuit was expected, they should have preserved everything. Because they didn't, she says, the court should assume the worst, that they intentionally destroyed evidence that would have proved retaliation. But again, there's a major problem. Assumptions aren't evidence. Courts don't convict based on what someone thinks existed, they need proof. Blake's team says they recovered some Signal data through Skyline, but only after December 2024. Nothing from before. Nothing from the exact months when she claims the alleged campaign took place. And yet, she's asking the court to fill in the blanks, to assume that those missing messages must have been damning. That's a dangerous line to cross. Because if the court agrees, it sets a precedent that anyone can accuse others of hiding evidence, even when there's no trace it ever existed. It's a gamble, and Blake's taking that gamble publicly. Behind the scenes, this move also raises questions about her strategy. Is it really about justice, or is it about reclaiming control of the narrative? Because every time another headline comes out questioning her integrity, this legal motion gives her a new story to tell, that she's being targeted, that powerful players are trying to destroy her name. And yet, people who follow the case closely point out that this isn't the first time Blake's team has shifted focus when the narrative turned against them. It's a familiar playbook. When the story starts to slip, redirect attention to an external villain. Insiders say Ryan's been extremely protective, managing public appearances, and keeping their circle tight while the case unfolds. But even his influence can't completely drown out the public's growing skepticism. Online, discussions have become split, half defending Blake as a victim of Hollywood politics, the other half calling her out for weaponizing her image when the facts don't add up. Legal analysts are equally divided. Some say her argument about the deleted messages might hold if she can prove that Wayfair's team had a duty to preserve data. Others believe this is a desperate attempt to shift focus away from the inconsistencies in her story. Because here's the reality: the burden of proof is on her. Without metadata, screenshots, or testimony verifying that those messages existed, she's asking the court to act on assumption, and that's not how the system works. Still, there's something undeniably fascinating about how this entire situation has unfolded. It's not just a legal battle, it's a war over perception. Every motion, every headline, every leak seems designed to control the story. The courtroom has become an extension of the Hollywood PR machine. And for all the noise, one fact remains. The so-called unsealed audio, the very thing that was meant to vindicate her, is what exposed the cracks in her narrative. Instead of confirming her as a victim, it painted her as someone trying to manipulate the system to maintain power over her image. Now, as this saga continues to unfold, the question isn't just whether Blake Lively can win in court, it's whether she can win back public trust. Because in today's world, reputation trials are fought online long before they ever reach a judge. And maybe that's the irony of it all. In trying to control her own story, Blake might have lost control of it completely. I think at this point, no one was surprised that Blake's legal team took it to the next level. Because when you look at her latest filing, it's not just another motion, it's a full-blown escalation. She's not asking the judge for a mild reprimand or a symbolic warning. No, Blake Lively is going for sanctions under Rule 37E of the Federal Rules of Civil Procedure. That rule deals with spoliation, which basically means the intentional destruction or failure to preserve evidence that should have been kept during a legal dispute. And this is serious stuff. She's not asking for a slap on the wrist. She's asking for some of the harshest penalties a federal court can hand down. So, what does she actually want? Let's start with the first demand, an adverse inference instruction. That's legal language for something incredibly powerful. She wants Judge Lyman to tell the jury that they can presume the missing signal and voice memo messages would have proven her case. In plain English, she's asking the judge to say, "Hey jury, you can assume those deleted messages supported Blake's story and proved a coordinated PR plot against her." That's not a small request, because once that instruction is given, the jury is legally allowed to fill in the blanks in her favor. It's like being given permission to imagine the missing pieces as evidence that supports her. She's essentially saying, even though I can't show you these messages, trust that they existed and they proved everything I've been saying. But it doesn't stop there. She also wants something called an issue of preclusion. That means she's asking the court to outright bar the defendants Wayfair, Wallace, and their PR partners from denying that they carried out the digital campaign she's accusing them of. She wants a judge to declare that as fact. Why? Because, according to her, the evidence proving that fact was destroyed. So in other words, she's saying, they deleted the proof, so the court should treat my claims as true. Again, her only proof that this evidence even existed is circumstantial. She has no hard data, no screenshots, no backups, no logs, nothing, just the assumption that because they used Signal and those chats disappeared, they must have contained something incriminating. And it gets even more ambitious. She's trying to use this alleged missing evidence to establish jurisdiction in New York over Wallace PR. She's arguing that the supposed concealment and destruction of records should count as proof that they were operating inside the state. That's a stretch, a long one, and most legal experts agree it's a shot in the dark. But she's not stopping there either. She's also demanding that the defendants pay her legal fees for filing this motion, which, again, is a bold move because sanctions like these are reserved for situations where there's clear and intentional wrongdoing. If you've been following along, this isn't even the first time she's gone this route. Remember, she's already filed sanctions motions before, including one that basically tried to have attorney Brian Friedman disbarred. And she's filed another under Rule 47.1, asking to be declared the presumptive winner in the Wayfair case altogether. Now, this time, she's asking the judge to do something even bigger, to forbid the defendants from even mentioning that the digital campaign might not have existed, and tell the jury that it did exist and that all the evidence proving it was maliciously deleted. And this comes just weeks after her attorney, Ezra, told the court that they couldn't respond to a motion on the judgment of pleadings because they didn't have enough time. Yet somehow, they had plenty of time to prepare and file this new motion for sanctions. The timing raises eyebrows for another reason. Not long ago, Blake's side told the court they had thousands of pages of evidence, ready-to-go evidence that, according to them, could amend her complaint and prove her case. But now, suddenly, she's saying she doesn't have evidence because it was deleted. So, which is it? It's a glaring contradiction, and that's exactly why critics are calling this entire situation messy. Now, let's break down what it actually takes for Blake to win these sanctions. There's a strict test, a set of criteria she has to prove. She needs to show that the evidence actually existed, that the defendants had a duty to preserve it, that it was lost because of their failure to take reasonable steps, that it can be replaced or recovered from other sources, and most importantly, that they intentionally destroyed it to deprive her of that information. That last one, the intent to deprive, is the hardest to prove, and that's where her case begins to crumble, because Judge Lyman has already ruled on this issue once before. He made it clear that using an auto-delete feature alone doesn't prove bad faith. You need to show deliberate destruction after being told to preserve evidence. And Blake, she never sent a preservation notice. She's relying instead on a letter she sent back in November 2023, a letter about workplace protections and returning to set. But that letter wasn't a legal notice. It didn't even include a threat of litigation. It was about sexual harassment claims, not retaliation, and all it said was that she reserves all rights. That's not enough to trigger a preservation obligation. Then there's the key date, August 29, 2025. That's when Judge Lyman specifically addressed the issue of the signal chats, and the auto-delete feature the same thing. She's now trying to sanction them over. In that ruling, he told her flat out, a party cannot be compelled to produce documents that don't exist. He said she hadn't shown any evidence that those messages ever existed in the first place. He accepted that Signal's auto-delete setting was active and that there was no sign of intentional spoliation. That should have been the end of it. But now, she's filing a new motion that's basically just a repackaged version of the same argument, the same claim. But framed differently, the only thing that's changed? The timing. Because this motion was filed right after her credibility took a major hit, right after the unsealed audio went public and public opinion turned against her. It's almost become a pattern at this point. Every time something collapses in her case, she files a motion for sanctions. When the Van Zam lawsuit fell apart, she went after Friedman, threatening him with disciplinary action. When that didn't work, she subpoenaed his law firm, made wild accusations, and tried to use the safe harbor rule to her advantage. It's like every legal setback is followed by a new attempt to reassert control, not just over the case, but over the narrative. And this latest filing? It feels like another attempt to shift the story away from the audio, away from the contradictions, and back onto her preferred storyline, that she's the victim of a coordinated campaign, that powerful PR forces conspired to ruin her career. But here's the reality. Courts don't work on feelings or assumptions. They work on evidence. And no matter how passionately her lawyers argue, without actual proof, without data, timestamps, or credible witnesses, this motion will likely fall flat. Even more telling is how the timing aligns with her public image issues. It's as if each legal maneuver doubles as a PR play, keeping her name in headlines, but under the banner of Blake Fights Back. The irony, though, is hard to miss. Every time she files one of these aggressive motions, it draws attention not to her strength, but to the holes in her case. Each filing is a reminder that she's still chasing evidence she can't prove ever existed. So now, everyone's watching, not just the fans, not just the legal commentators, but the industry too. Because at this point, the question isn't only what happened behind the scenes, it's how far she's willing to go to protect the story she built. And maybe that's what makes this entire saga so captivating. It's not just about missing messages or deleted signal threads. It's about a celebrity who spent years mastering her image, suddenly losing control of it in real time. The more she tries to force the narrative, the more unpredictable it becomes. And if this latest motion fails, as most experts predict it will, it might finally expose the one truth she's been trying hardest to hide, that sometimes the story isn't lost in the deleted messages, it's lost in the contradictions you create yourself. At this point, it's almost predictable. Every time something happens that's even slightly favorable to Wayfair, another motion for sanctions from Blake Lively's team follows soon after. It's become part of a pattern, an almost reflexive reaction every time the tide shifts against her. When the court moves one step closer to dismissing her claims, or when public opinion begins to turn, Blake's legal strategy seems to shift into attack mode. And this time, it's no different. Right after the unsealed audio dropped the same recording that contradicted her harassment narrative, her team knew they had a problem. They knew it was coming. Insiders say they've been bracing for the release for weeks, because the moment that audio became public, it would paint a very different picture than the one they'd worked so hard to present. The original idea behind the tape was simple. It was supposed to make Blake look like a victim, a woman wronged, mistreated, and silenced in a toxic work environment. But when the world finally heard it, that story fell apart. The audio didn't show harassment or abuse. It showed control, manipulation, and ego of power struggle over creative direction, marketing, and public image. So when it became clear that the audio wasn't going to help her case, her team needed a counter-move, something to change the conversation, something that would shift the focus back to her being the one under attack. And that's when the new filing appeared in motion for sanctions. After days of silence on the court docket, suddenly, there was a massive legal filing accusing Wayfair and its PR partners of destroying evidence, hiding communications, and obstructing justice. The timing wasn't coincidental. It was strategic. Public opinion had started to flip again. Even the mainstream entertainment press, which had largely been sympathetic toward her, began to question her motives. Outlets that once framed her as the brave whistleblower were now running headlines asking if Blake Lively was manipulating the system. So this new motion? It wasn't just about the courtroom, it was about optics. It was about reclaiming her image. By filing this, she could go back to the press and say, "I can't prove it because they destroyed the evidence." It's a line that plays beautifully in PR terms. It reinforces her as the victim, the one silenced not by truth, but by corporate deceit. But in legal reality, it's much weaker, because in a courtroom, feelings and assumptions don't win cases. Evidence does. And that's exactly what she doesn't have. For Judge Lyman to grant sanctions, she'd have to prove, not speculate, that the defendants intentionally destroyed messages. She'd have to show that these signal and voice memo chats existed, that the defendants had a duty to preserve them, and that they deleted them in bad faith to keep her from proving her claims. That's a massive hill to climb, and legal experts don't believe she'll get there. Lyman's already ruled once before that simply using auto-delete doesn't prove intent. You can't just point to an app's feature and call it malicious destruction. He's been consistent about that from day one to prove spoliation. You need intentional, deliberate acts of deletion after you've been formally told to preserve evidence. And Blake never issued a proper preservation notice before the alleged deletions. Her team tries to argue that her earlier correspondence, a 2023 letter about workplace harassment and returning to set, should count. But that letter wasn't a legal threat. It didn't mention litigation or evidence preservation. It just said she reserved all rights. That's not a trigger for a duty to preserve under federal standards. Even worse, most of the documents she cites in this new motion are sealed or heavily redacted. That means the public and even large portions of the court's record don't have full visibility into what she's referencing. It makes her claims feel murky, like a puzzle with missing pieces. From the outside, it's hard not to notice the contradiction. She's asking for one of the harshest sanctions possible, an adverse inference instruction, where the judge tells a jury they can assume the deleted evidence would have proven her case. She's also asking for issue preclusion, meaning the court should treat her claims as true and prevent the defendants from even denying them. But she's doing all this without any actual proof that the deleted material ever existed. That's why legal analysts are calling this a Hail Mary, a last-ditch effort to reset the conversation when the facts aren't aligning. Still, in her motion, she paints the picture dramatically. She claims that the defendant's obstructive conduct in the litigation proves that sanctions are appropriate. She says that she only recently obtained the key facts after overcoming substantial discovery hurdles that the defense allegedly created. She writes that there is no dispute that each of the defendants used Signal as an informal messaging platform to discuss issues related to this litigation, and that the court has already acknowledged that fact. According to her, she first requested these communications on February 20th, and both sides agreed to an ESI protocol, basically a digital evidence agreement that required manual review of communications among all parties involved. But then, she says, months passed, nearly 6, and the defendants refused to produce anything. Every time she asked, they responded the same way: "We cannot produce what we don't have." In her words, that became the foundation for this motion. She cites the Wallace defendants' admission that because they didn't disable Signal's auto-delete feature, no responsive communications remain in their possession, custody, or control. And the court accepted that. Judge Lyman already ruled that they couldn't be compelled to produce documents that didn't exist and found no evidence of intentional spoliation. He even issued a clear order on the timeline, instructing the Wayfair parties to produce whatever remaining Signal communications existed by September 8th. But according to Blake's new filing, instead of complying, the defendants made a last-minute request for a 1-week extension. When that was denied, they allegedly turned to self-help, producing only a handful of messages at the 11th hour. Blake's team is using that small production as proof of misconduct, arguing that if some messages survived, more must have existed. But again, that logic doesn't necessarily hold. Apps like Signal are designed to protect privacy, and the auto-delete feature is automatic unless users disable it manually. There's no evidence that the defendants did anything beyond using a secure communication platform, something millions of professionals and journalists use daily. Legal insiders say this is where Blake's case weakens. She's trying to turn a routine privacy setting into evidence of a criminal-level cover-up, and the court has already warned her against doing that before. Still, from a storytelling perspective, her motion is powerful. It's written with emotional intensity, almost like a script itself. She leans into phrases like untraceable, no fingerprints, and digital conspiracy. She paints a picture of corporate elites coordinating against her through encrypted apps and voice notes that vanished into thin air. It sounds compelling, the kind of narrative that plays well online, where fans want heroes and villains. But in a courtroom, where emotion has to meet evidence, it may not survive the scrutiny. That's why most analysts expect Judge Lyman to deny the sweeping sanctions she's asking for. At most, he might allow limited questioning, maybe acknowledge that some signal data wasn't preserved. But the idea of instructing a jury that deleted evidence proved her case? That's a leap the court probably won't take. Because here's the bottom line, the burden of proof still rests with Blake. And after all these months, she hasn't met it. Her case is starting to look less like a fight for justice and more like a battle for narrative control. Every legal filing doubles as a press release. Every motion seems to arrive at the exact moment the headlines start turning against her. And maybe that's the real strategy to keep the story alive. Because as long as Blake's team can frame her as a silenced whistleblower, the victim of some invisible digital smear campaign, the conversation never fully leaves her favor. But behind the theatrics, the legal reality is much simpler. The court has already said there's no proof that anything was intentionally deleted. There's no proof that these messages ever existed in the first place. And that leaves her right where she started, with a story that sounds convincing in interviews, but collapses under legal scrutiny. If anything, this latest motion exposes a fragile foundation of her case. It's built more on assumption than evidence, more on timing than truth. And every time she files another round of sanctions, that foundation cracks a little further. Because while you can fight the media with narrative, you can't fight the court with speculation. And if history repeats itself as it seems to be doing, Judge Lyman will likely see this for what it is. Another desperate attempt to redirect attention after another blow to credibility. The bigger question now isn't whether she'll win this motion. It's whether this constant cycle of reactionary filings is doing more damage to her case than anything Wayfair could ever have done. Because in the end, the court of public opinion might be the one battlefield she can't control. At this stage in the ongoing courtroom drama, things are getting stranger by the day. Blake Lively's legal team has filed yet another motion, this time accusing the Wayfair defendants of playing a digital disappearing act, producing their signal messages late, trickling them out over random intervals, and allegedly withholding critical evidence. According to the new motion, Wayfair's lawyer produced signal communications far past their deadline, first in bits and pieces, then sporadically over the following weeks, with no real explanation for the delay. The last batch didn't come until October 9th, nearly a month after the court's order. But here's the kicker. None of those messages predate December 20th. And that date, December 20th, is no coincidence. It's the day Wayfair's team claims the preservation duty officially began. Before that, they say they weren't legally required to save or back up anything. Still, Lively's team insists that this late, uneven production shows a pattern, what they call a systematic failure, to comply with discovery obligations. They argue that the defendants have refused to provide a full privilege log for the withheld signal chats, which makes it impossible to know what was truly deleted and what might have existed. On paper, it sounds sinister, but when you look closer, the argument starts to fall apart. Because what Blake's lawyers are really saying, if you strip away the legal jargon, is this. They used apps that don't automatically save messages, and that means they must have been hiding something. In other words, she wants the court to punish them for using Signal, for making phone calls, or for sending voice memos that delete automatically. She's claiming that all of this was done intentionally, part of a deliberate, untraceable smear campaign to destroy her reputation. It's an explosive accusation, but there's one glaring issue. There's still no proof. In fact, when you read between the lines, what she's actually telling the judge is almost an admission of defeat. She's saying, I can't prove my case. I don't have thousands of pages of evidence. I can't amend my complaint to show that this smear campaign really happened because the evidence isn't there. And since I can't find it, you should assume they destroyed it. It's a risky argument, one that asks the court to fill in the gaps that her case can't. Ironically, buried within her own filings is the very evidence that undermines her entire claim. There was, in fact, a preservation notice, the first formal legal order requiring Wayfair and its co-defendants to save their messages, and it was issued on December 20th, 2024. That notice, which is attached to the public docket, clearly states that as of that date, the parties were required to preserve all relevant communications. In other words, before December 20th, there was no binding obligation to save Signal chats, voice notes, or texts. And yet, now, months later, Blake's lawyers are trying to argue that the duty actually began earlier back in November, when she sent a private letter saying she reserved her rights. That letter wasn't a legal document. It didn't threaten litigation. It didn't instruct anyone to preserve evidence. It was essentially a PR statement, a vague warning that maybe someday she might take legal action. Try to reinterpret that as a formal preservation notice is a stretch, and everyone knows it. Even seasoned attorneys are calling a clear case of retroactive gaslighting. Because what she's really doing here is rewriting the timeline. She's trying to convince the court and the public that it's Wayfair's fault she can't prove her case. And from a PR perspective, it's smart. It gives her an excuse. To her audience, she can say, they destroyed the evidence. That's why I can't prove my case. But to the court, that argument doesn't hold water. The truth is, after nearly 10 months of aggressive litigation, dozens of depositions, hundreds of subpoenas, endless discovery, Blake Lively has still uncovered nothing. Not a single shred of evidence showing that anyone at Wayfair orchestrated a coordinated smear campaign against her. Not one email, not one memo, not one message tying her allegations together. It's a devastating realization, and one her legal team seems desperate to cover up with noise. They keep insisting there's a grand conspiracy, that everyone from publicists to executives were communicating through untraceable channels like Signal to hide their misconduct. But when you step back, it starts to sound absurd. If simply using an encrypted app like Signal makes you guilty of obstruction, then millions of journalists, lawyers, and even government officials would be in trouble too. These apps are used precisely because they protect privacy, not because they're part of a secret cover-up. That's why this motion feels less like a legal argument and more like a PR maneuver. It's designed to buy time, to distract, and to shift the narrative just as things start to collapse. Because make no mistake, the clock is ticking. In just a few weeks, the summary judgment motions are expected to be filed. That's the point where both sides present their full evidence or lack thereof, and the judge decides if the case can even go to trial. Wayfair's team is reportedly confident. They believe they built a clean record, full transparency, documented communications, and absolutely no proof of any coordinated smear effort. And when that motion hits the docket, it'll lay everything out in black and white. No proof of deleted evidence, no proof of malicious intent, and no proof that a smear campaign ever existed. When that happens, Blake's entire argument falls apart. That's why, according to several legal analysts, this sanctions motion is nothing more than a preemptive strike, a way for her to get ahead of the bad news. If she knows she can't win on facts, the next best option is to control the narrative. By filing this motion now, she plants a seed in the public's mind. If I lose, it's because the evidence was destroyed. It's a safety net not for her legal strategy, but for her image. And the irony is thick, because just months earlier, Blake had accused the defendants of a smear campaign before any of the alleged conduct even happened. She was already talking about being targeted before the supposed conspiracy began. In other words, she claimed to be a victim of a campaign that didn't exist yet. That's why so many in the legal community see this as a pattern. When the facts don't match her narrative, she shifts the timeline, reframes the argument, and finds a new villain. Now the villain isn't Wayfair. It's Signal. It's technology itself. She's essentially telling the judge that anyone who uses an encrypted app or deletes a voice memo must be hiding evidence that privacy equals guilt. If that argument were accepted, it would set a dangerous precedent. It would mean that millions of everyday users, anyone using Signal, WhatsApp disappearing messages, or iPhone's voice memo app, could be accused of spoliation of evidence just for using normal features. It's not just unrealistic, it's absurd. And that's why most legal experts believe this motion will fail spectacularly. But failure in court doesn't mean failure in the media. And that's where Blake has always been a step ahead. For her, each filing serves a double purpose, one for the judge and one for the headlines. Even when she loses a motion, she wins attention. Even when the facts crumble, the story keeps going. This latest motion fits perfectly into that pattern. It's less about evidence and more about optics. It's about telling her fan base, I'm still fighting. I'm still being silenced. I'm still the victim of something bigger than me. It's emotional storytelling disguised as litigation. But the deeper truth the one her team doesn't want to admit is that after all this time, all this money, and all this noise, she can't prove her claims. 10 months, hundreds of subpoenas, dozens of depositions, and not one piece of verifiable proof. At this point, even her own filings sound like confessions in disguise. They read less like evidence and more like excuses. Her lawyers are now hinging everything on the hope that Judge Lyman will punish the defendants for something that cannot be proven, that he'll assume intent where there's only speculation. They're hoping he'll tell the jury that Wayfair destroyed evidence not because there's proof of that, but because they can't find anything else to hold on to. It's a long shot, and everyone knows it. Even legal commentators covering the case have started to laugh at the absurdity. They've said they've never seen attorneys act this way, filing motions that seem more performative than persuasive. But then again, this isn't an ordinary case. This is Blake Lively and Ryan Reynolds, two Hollywood powerhouses with reputations, brands, and millions of followers to protect. And in that light, everything suddenly makes sense. Because the courtroom isn't the only battleground here. The real war is happening online in social media feeds, entertainment blogs, and YouTube videos. Every motion, every headline, every leaked document becomes part of a larger performance. The big takeaway? This motion, the one about deleted signal messages, is more than just a legal filing. It's a mirror reflecting the truth that Blake and Ryan's team knows they can't win this case based on evidence. They're trying to win it through perception. They're hoping the court of public opinion will overrule the court of law, but the cracks are showing. As more people read the filings for themselves, they're starting to see the contradictions. The timelines don't add up, the claims don't align, and the evidence or lack thereof tells its own story. This isn't a story about deleted messages. It's about a case built on assumptions, fueled by ego, and driven by fear of losing control over the narrative. Because in the end, what's becoming clearer every day is this: Blake Lively doesn't have the proof. She doesn't have the documents. And she doesn't have the facts to back up her claims. So instead, she's trying to rewrite reality one motion, one headline, one press leak at a time. But reality always catches up. And when summary judgment hits, no amount of PR spin or emotional storytelling will save a case that was never built on evidence to begin with. Because the truth doesn't vanish, even when the messages do. This new motion from Blake Lively's team isn't just another legal filing. It's what many are calling a harebrained sanction request. A desperate swing in the dark that asks the court to make a leap of faith no reasonable judge would take. Essentially, she's asking the court to tell the jury that the defendants deleted evidence not because there's proof of deletion, but because she says so. The entire foundation of her motion rests on assumption and speculation. She wants the jury to be told, they destroyed messages that would have proven my case, and because of that, you must assume I'm right. It's a stunning request. In effect, she's asking the judge to rewrite reality, to replace evidence with imagination, to tell a jury, even though no one can prove this ever existed, pretend that it did, and pretend that it supported her story. Won her.